Can your beneficiary also be the trustee of your trust? Well, the short answer is yes. The long answer is yeah, of course, if you want. But the real question is not whether one of your beneficiaries can also be the trustee of your trust, but would you even want them to be that in the first place? And that's what we'll be talking about today, because as often is the case with the law, a simple question may have a simple answer on the surface, but the simple answer requires a lot of explanation to get there in the first place. So with that, I'm attorney Andrew Bethel, California's go-to YouTube estate lawyer, award-winning, never mind the fact that the judge is my 3-year-old son, here to make estate planning, taxes, and the legal stuff a bit less boring, or at least a bit more manageable. Let's talk trustees and leaving the fox in charge of the hen house. Please like the video, drop a comment, subscribe to see more, and share the video with your aunt who can't make up her mind, and let's learn a little something. Firstly, let's get the basics out of the way. When you set up your revocable living trust, then 99% of the time, you are going to be the first beneficiary of your trust and the first trustee of that trust. It's your trust and your stuff, so it makes sense to keep you in charge of your own life, presumably. But let's assume you can manage your own life. What we're really interested in is in who takes over that management role, the trusteeship, after you die. Let's be clear, in the overwhelming majority of cases, you are going to be picking one of the beneficiaries to also be the trustee of the trust. Then, in most of the cases where you pick someone else, it's typically because the beneficiaries themselves are either just too young to serve in that role, whether it be because they're not yet 18 years old, a legal requirement, or we think they just aren't mature enough to do it in the first place. And there are advantages to picking one of the beneficiaries to also be the trustee of the trust. Firstly, they have a stake in the game. Trustees have a legal obligation to operate in the best interests of the beneficiaries of the trust, which we'll talk about the legal obligations of trustees in a moment. But there's something to the psychological effect of the thought, well, if I screw this up, I'm going to lose something too. Trustees who are also beneficiaries often have a personal stake in the success of the trust, potentially leading to more attentive management of the trust assets. That may be a double-edged sword, but we'll come back to that point. Another advantage, however, is the decision-making may be more simplified or at least streamlined. Having aligned interests with other beneficiaries can streamline decision-making, reducing the need for complex negotiations between the trustee and the beneficiaries. Is this the right price to sell the asset for? Should I just do an estate sale and donate or throw out the rest? If a beneficiary trustee also has the same incentives as the other beneficiaries, then it should be easier, in theory, to make a decision that's in their best interest. And lastly, another advantage is that it may save the estate a little bit of money to have one of the beneficiaries also serve as a trustee, because trustees are entitled to compensation for their services as trustee. You can limit this compensation, but let's assume you don't, since if you did, people would be less likely to accept the job. And it really is a job. When you serve as a trustee of a trust, you have legal obligations that you must adhere to and have a lot of work to do. Closing down bank accounts, selling or transferring real estate, cleaning up personal property, selling or transferring vehicles, filing tax returns, among many other tasks. If a trustee elects to receive compensation for their services, then that compensation is taxable income to them. However, most of what a beneficiary will receive as an inheritance will come to them tax-free. Thus, why increase your taxable income by 10 grand when you'll be receiving much more than that tax-free anyway? But this is where experience comes in. In our experience, trustees will rarely forego trustee compensation unless they're the only beneficiary, the work is very easy, or they're getting so much anyway that it doesn't really move the needle to collect that little bit of extra money in the end. As I said before, being a trustee is a lot of work. Go watch my video guide for trustees when administering trusts after death to get a sense of the work that is entailed to administer a trust. Because it can be a massive time sink and a lot of stress, most reasonable people will be completely fine with the trustee taking compensation because they're just thankful they didn't have to do it themselves and only had to sit back and collect an inheritance. Next, let's discuss a few risks to choosing a beneficiary to serve as a trustee, starting with the obvious. If you're going to put any sort of restriction, condition, or limiting parameter on a beneficiary's distribution, then it probably doesn't make sense to also put them in charge of adhering to those rules. Again, does it really make sense to put the fox in charge of the hen house? The beneficiary is the watchdog of the trustee. Trusts are, by their very nature, private affairs, meaning we don't have courts and judges poking their noses into the process, so the beneficiaries are there to make sure the trustee remains honest and does what they're supposed to do. Not to say that your kids or beneficiaries are dishonest, but if you left a stack of cookies sitting on the table with a note that said you pinky promise not to touch until you finish your homework, but even if you do, I'll never know, what do you think they're going to do? On the note of dishonest children, another risk is that of a conflict of interest between the trustee's interest and that of the other beneficiaries. For example, being in the position of authority, trustees might favor themselves in decisions or manipulate trust assets for personal gain, undermining the integrity of the trust. However, I would argue that this is a risk with whoever you pick to be trustee of the trust, whether it be one of the beneficiaries, another family member, or a neutral third party. This is where the fact that the beneficiaries are the watchdogs of the trustees comes back into play. The beneficiaries are entitled to information relevant to their interests, accounting of the trust assets, must be able to communicate with the trustee, and must be kept in the loop as to the actions of the trustee. If the trustee is doing something stupid or something they're not supposed to be doing, then the beneficiaries have the right to sue that trustee, hold them personally liable, and have them removed as trustee. And wouldn't you know it, I have an excellent video on everything you need to know on trustee removal, resignation, and death when administering a trust. If you want to know more or any of those topics, then watch that video. Before you go, I do want to highlight some key duties of a trustee when administering a trust. I plan on doing a video where I talk only on trustees' duties, but today I want to highlight 3 important duties that are related to each other, beginning with the duty of loyalty. California Probate Code Section 16002 specifies that a trustee must act solely in the best interest of the beneficiaries, avoiding any self-dealing or benefiting personally from trust assets. Pretty straightforward. Trustees cannot benefit to the detriment of the beneficiaries due to their positions. Trustees operate in a fiduciary capacity. An extreme example, but one where there is actual case law on, was where a trustee paid for some trust expenses on their personal credit card and then reimbursed themselves for that out-of-pocket expense. Now that's allowed, but there must have been some great family drama there because one of the beneficiaries sued and the court found that the trustee breached their duty of loyalty because when they used their personal credit card to cover expenses, they personally benefited by the fact that they received points for the expenses paid through their credit card. I'll just let that sink in for a moment. Next is the duty of impartiality found in Probate Code Section 16003, wherein trustees must treat all beneficiaries fairly, avoiding favoritism even if the trustee is also a beneficiary. Obviously, this relates to the duty of loyalty and is essentially that duty but targeted among beneficiaries. Trustees must treat everyone fairly and not give themselves first dibs on mom's crystal glassware or dad's Gibson Min-E-Tune self-tuning guitar. And last is the prohibition from profiting highlighted in Probate Code Section 16004. Trustees cannot derive personal profit from their position unless compensation is explicitly allowed by the trust instrument or by law. Most trusts, even some of the really bad ones out there, will explicitly address and allow trustees to receive compensation for their work. However, even if a trust fails to address trustee compensation, Probate Code Section 15680 allows trustees to receive reasonable compensation for their services if the trust fails to specify. What is reasonable compensation? Well, it's typically 1 to 2% of the assets under management. With that, a trustee must stay within the parameters set out in the trust or by default in the probate code. They can always elect to receive less, but if they push the envelope and try to grab more, then they may be in breach of their trustee fiduciary duties and run the risk of personal liability and/or removal as trustee. With all that being said, if you trust the person you're picking to be honest and organized as a trustee, then if they happen to be a beneficiary as well, then so what? Whoever you pick is most likely going to want to receive compensation because it's a lot of work. If they aren't normally fair, honest, and reasonable, then they shouldn't be in the running for trustee in the first place. And if they're also a beneficiary, then they're also likely related to everyone as a member of the family, and thus will likely have a greater success at working with everyone involved anyway. Sometimes working with many beneficiaries can feel like herding cats, so it may make the process a bit easier if the trustee also has the ability to call that nephew at 10 o'clock at night and tell him to stop being a knucklehead and sign off on getting his portion of the life insurance proceeds. I recommend my clients to first look inward for a trustee when deciding who to put in that position. And only once they either exhaust that list or we don't want to have one of them serving that position due to age or immaturity, should they then begin to look elsewhere. But this is where I pass it off to you. Have you decided to name your son or daughter as trustee? Do you not trust them, or would you rather pick your sister or family friend instead? Or have a question or a topic? Let me know in the comments below. I'll answer you, probably with an "it depends," but you'll get an answer. As always, don't forget to like, share, and subscribe to learn more on how to protect your estate from that son who can't seem to manage a buck. I'm attorney Andrew Bethel, and I'll see you at our next meeting.